Great. Good afternoon, everyone. We'll give everyone a few minutes to filter in from the waiting room. Great. Well, I'll go ahead and get us started so we take advantage of the hour that we have. Thank you, everyone, for joining us. I'm Louise Bedsworth. I'm the Executive Director for the Center for Law, Energy, and the Environment, a research center at Berkeley Law. CLEE is a policy research center that focuses on really advancing practical and pragmatic solutions to some of our most pressing environmental challenges. We work a lot within the state of California, but also broadly in the international space as well to really look at collaborative and interdisciplinary solutions. We use our Lunch and Learn series to dig in on a number of emerging topics, share research findings, and just host dialogue around a lot of current and pressing issues. So really, thank you so much for joining us today. Our Lunch and Learn series is made possible by our partners, Wilson Sonsini, Oric, and Hanson Bridget. And today we get the opportunity to reflect on this year's legislative session and some of the outcomes from that, which is always a busy and dynamic time in environmental policy in California. And so we are joined by three experts today. We have luckily had Dave Owen, one of our advisory board members and professor of law at the University of California, San Francisco Law School, joining us in the place of Nell Nylen, who unfortunately could not join us today. But we have three experts here to help us unpack and walk through some of what happened in the legislature this year. And I think it's important to just always look at the legislative session as always a continuum of activity punctuated by really big bills and then a lot of important actions that help us to implement big and meet big policy goals. And I think this year is an interesting combination of a lot of those things. Last year, we saw a suite of climate bills that codified the state's carbon neutrality target, established legislative and regulatory frameworks for carbon removal, both engineered and natural systems, started really building out more of a resilience framework, especially as it pertains to extreme heat. And so there was a lot of activity last year. And I think looking at this legislative session, a really interesting mix of bills that are going to help us implement the policies and take down some of the barriers to meeting our carbon neutrality target. So Ethan Elkind is going to help us walk through some of those actions in the climate and energy space. I think we also saw the opening of a whole new important area of policy and leadership for California in climate change, and that's in the area of climate risk and greenhouse gas emissions disclosure. And we have Dave Jones here to help us walk through that. And then finally saw important action on water, which often referred to as the third rail of environmental policy in California, an area where certainly are seeing the stresses of changing climate conditions and the need for modernizing both our governance and physical systems to ready that system. And I think started to see some action on water this year with certainly more to come. And we have Dave Owen here to walk us through that. And so I think we will turn to each of our speakers to share a few opening remarks. We'll do some moderated question and answer. Certainly want to open it up to everyone who's attending and in the audience, and would invite you to drop questions into the Q&A function that we will queue up after we go through some introductory remarks from each of our speakers. So with that, I will turn it over to you, Ethan. Thank you, Louise. Good to be here as the one non-Dave speaker on this panel. So I'm holding down the fort for the non-Daves. And it was great to talk about the legislative session. I'm going to talk about a number of bills, a little bit of a laundry list, but I've organized them as bills related to transportation, bills related to electricity grid, and bills related to some specific types of renewable power. And I guess the big picture here when we think about this last legislative session is that
there really weren't any big goals set. This wasn't a legislative session all with, we're going to reach for this milestone by 2030, 2045. This legislative session, at least on the climate and energy side, is really typified by implementation. We've got these big goals. How can we as a legislature help speed up deployment of the resources that we need on the clean energy side and the clean transportation side? So that really is I think the sort of the way I would describe how the legislative session went down. So I mentioned I'm going to talk about transportation grid and some specific renewable power sources. The one area I'm not going to cover, at least in the opening here, is housing, which I actually think is one of the most central ways that California can achieve our climate goals. So I can maybe talk about that in some of the question and answer session, but I really just want to focus for now on climate and energy and a little bit of transportation. So on the transportation subject, there are three bills that I wanted to point out for folks. So the first one actually is a bit of a goal. It's AB 579 from Assemblymember Ting that does actually put forth a mandate for electric school buses. It requires 100% of all new school buses be zero emission by 2035. And this sort of parallels our broader goal in the state to phase out the sale of internal combustion engines and new vehicles by 2035. So this is an important equity issue because school buses affect a lot of disadvantaged communities. They're very polluting if they're internal combustion engine. And so moving towards electric buses certainly will provide a lot of health benefits, obviously climate benefits too. And then beyond that, it helps save money from the school districts from having to pay as much for fuel because electric buses may be a little more expensive to buy, but much cheaper to operate in fuel. Second bill under transportation, very quickly, AB 126 from Reyes, which was a sort of compromise spending package that'll devote more than $1 billion to clean transportation over the next dozen years. A little bit of a controversy. This was held up by hydrogen fueling interests that really wanted to see hydrogen get a carve out. And there's a lot of controversy over hydrogen, which we could maybe talk about separately, not as much legislation to talk about, but that's an interesting dynamic when you get this kind of battery versus hydrogen debate going in the legislature around clean fuels. The last transportation bill I'll mention is Senate Bill 695 from Gonzalez, which requires the Department of Transportation, Caltrans, to release more information about their highway projects. This is a consistent complaint among many advocates that Caltrans was really not transparent in terms of the projects that it's funding. There was a recent controversy some of you may have seen in the news where Jeannie Ward Waller, who really was appointed to Caltrans in part to bring about more sustainability, more walkability to Caltrans steps and actions, was actually demoted allegedly for complaining internally about highway widening projects. And I think Senate Bill 695 starts to build a little more transparency into Caltrans process. It's not necessarily going to reform how we fund and build highways in the state, but is at least a step in that direction towards transparency. So those are the three transportation bills I wanted to flag. And maybe more importantly, this legislative session were some of the bills on the electricity grid, because this is a big stumbling block to deploying more renewable energy. Is the electricity grid is antiquated, the processes for approval, interconnection, energization is very slow. So I want to talk about three different bills under the sort of electricity grid rubric. The first is a transmission bill, SB 619 from Senator Padilla, which expedites environmental review of transmission projects, basically gives them the same access to expedited judicial review that we've seen large projects in the state get, particularly sports stadia, Apple headquarters, some of these projects that pledge to do well under greenhouse gas and vehicle miles traveled metrics. They get to go through the Court of Appeals within 270 days for any CEQA litigation, CEQA challenges. So transmission now will get those benefits. Secondly, SB 49, which basically allows the Caltrans Department of Transportation to have more authority over siting solar and transmission and their rights of way. And this is a big deal if we can get more solar panels along highway rights of way. If you think about how Caltrans owns and manages 52,000 miles of state highways, 15,000 miles of federal interstate highways that crisscross California, all of these now potentially under Caltrans authority could start to see more transmission lines and more solar panels which could greatly help with our renewable energy goals. The last bill I'll mention on the electricity grid is SB 410 from Senator Becker in the South Bay, here in the Bay Area, which is really an effort to expedite hooking up new clean tech resources to the grid, what we call interconnection or energization. I think the lingo is sort of changing on that. But SB 410 now allows utilities to move more quickly without having to wait for approval from the California Public Utilities Commission for some of the spending they would do to upgrade the grid. Also put some deadlines on the California Public Utilities Commission to increase the timeline, speed up the timelines for energization. So I think this is a really central, really important reform. SB 410 passed with bipartisan overwhelming support. And even when you think about things like deploying charging stations for heavy duty vehicles like clean trucks, one of the major issues is the grid is inadequate and the interconnection delays are slowing things down. SB 410 can go a long way towards helping speed up those sort of behind the scenes processes that really do speed up, really hinder deployment. So again, SB 410 from Becker. The last bucket of bills I'll mention before I let the Daves go forth is on specific renewable energy. One I'll flag on offshore, a couple of bills I'll flag on offshore wind, which is an area that CLEE has been focused on helping California, bringing stakeholders together to talk about how we can get offshore wind sited more environmentally sensitively and meet our offshore wind goals at the same time. So a few bills there I want to flag on offshore wind. AB 1373 from Garcia, which allows the Public Utilities Commission to authorize the Department of Water Resources to do its own procurement for offshore wind, which is a big issue. These are big energy projects and huge procurement contracts, and the Department of Water Resources will end up with the authority potentially to procure that power. AB 3 relatedly requires state officials to prepare our ports for offshore wind power. All this power is going to be, all the deployment of these, physical resources are going to be going through ports. There's opportunities for manufacturing of ports, potentially transmission coming into ports as well. So AB3 helps get state officials doing that planning process. And then last on offshore wind, SB 286 from incoming Senate Leader Mike McGuire and from Healdsburg, that's meant to speed up the permitting for offshore wind farms and make sure that that can happen faster. A couple other renewable energy sources I'll mention. Wave energy, for all of you wave energy fans out there. SB 605 from Padilla requires the Energy Commission to study the possibility of generating power from the waves and tides, with a report due by January 2025. And on the rooftop solar, I'll conclude with this. AB 1132 from Assemblymember Laura Friedman would extend existing caps on permitting fees for solar rooftop, and SB 355 from Eggman would ensure continued funding for solar panels on low-income housing. And for those of you following the rooftop solar debate, you'll know that the Public Utilities Commission this year pretty dramatically scaled back incentives, the rate in the rate structure and incentives that rooftop solar customers get. So this is at least a bit of a win for the rooftop solar industry to cap permitting fees and encourage more solar panels on low-income housing. So that was my data brain dump of recent climate and energy legislation. I will pause there and let the other panelists pick up from there.
Great. Thanks so much, Ethan. I will turn it over to Dave Jones. Dave, I think a little audio issue.
Now, great. So I have a far easier task, which is just to talk about two bills, as Louise described, our first foray by California into the realm, at least legislatively, of dealing with disclosure of both financially related climate risks as well as carbon pollution, that is greenhouse gas emissions. The first of these two bills, SB 253 by State Senator Scott Wiener, will require, for the first time anywhere in the United States, that corporations, both public and private, of a certain size, disclose their greenhouse gas emissions. The provisions of the bill provide that they're to begin doing so by January 1st, 2026, that they're supposed to report Scope 1, Scope 2, and Scope 3 emissions. Remember, Scope 1 emissions are those directly caused by the company. Scope 2 emissions are those emissions associated with the energy utilization by the company. The Scope 3 emissions are the emissions of the supply chain for the company, as well as the downstream entities that are purchasing and using the goods or services of the company. The inclusion of Scope 3 is a big deal. And what's also a big deal is that these disclosure requirements, which will land on companies doing business in California that have over $1 billion in revenue a year, which is about 5,300 or so companies, that there's no materiality requirement associated with these disclosures, as is the case with the SEC proposed rule, which would only apply to stock companies, which requires that which has to be disclosed has to pose some material risk to the enterprise. The other big deal here is that CARB is supposed to have regulations done by January 1st, 2025. Reporting is supposed to begin January 1st, 2026. There are no criminal or civil penalties for failing to report. However, CARB is directed to do a regulation that would provide for administrative penalties capped at $500,000 per entity for failure to report or failure to report adequately. The second major disclosure bill is the Climate-Related Financial Risk Act by State Senator Henry Stern, Senate Bill 261. And what this one does is require biannual reporting by corporations of a certain size of the financially related climate risk they face. So it goes beyond greenhouse gas reporting to require companies to report the risks they face from the physical impacts of climate change, as well as the transition impacts of climate change. That is, as we transition away due to technology, market changes, policy, legislation, away from an economy that relies substantially on greenhouse gas emitting and in particular fossil fuel enterprises, as we transition away, that poses certain financial risks to the value in those enterprises that are in those sectors that we're transitioning away from. And so, in addition to the physical risks that a company might face, the transition risks that are faced associated with the transition away from a greenhouse gas emitting economy have to be reported as well. The bill requires reporting be done pursuant to the TCFD framework, which is the Task Force on Climate-Related Financial Disclosures, which is a framework that's been adopted globally, both at the national level as well as by individual corporations and associations of corporations. It requires reporting of governance strategies to address climate risks, governance provisions to address climate risk strategies, metrics and targets, and also what the company is going to do vis-a-vis risk management. And then the new law requires companies to also disclose what measures they're taking to reduce those risks. Again, reporting is done biannually. It'll start in January 2026. This applies to corporations that have at least $500 million in revenues annually that are doing business in California. So it reaches some 10,000 corporations nationwide. And like the greenhouse gas disclosure bill, it applies to both private and publicly held companies. No civil or criminal penalties, administrative penalties of $50,000 per year if CARB finds a violation. The bill does not apply to insurance companies because the National Association of Insurance Commissioners Climate Risk Survey has now incorporated the TCFD framework, and California's Department of Insurance has embraced that. And so the bill excludes insurance companies from reporting. It is the case that the risks here have to meet a materiality standard. They have to be financially material to be reported, which is an important precondition. And you can meet the requirements of this bill, SB 261, if you prepare a report that's substantially in requirement with the bill's requirements, but is also required by a national governmental entity or an exchange. And this refers to the potential adoption by the SEC of its own rules. So if you prepare a report congruent with the SEC requirement, you would meet the SB 261 requirement. So why do these matter? Well, fundamentally, you can't manage what you don't measure. And the United States government, California, various private sector enterprises, various associations of private sector enterprises have all made commitments in various ways to reduce greenhouse gas emissions over some period of time. If we don't know what the emissions are from the private sector, there's no way to really understand what progress we're making, as well how we can better manage and reduce those emissions over time. So too with regard to reporting climate risks, the Federal Reserve, the FDIC, the OCC, the credit union regulator, the Department of Treasury have all concluded that climate change poses a systemic risk to the U.S. financial system and a potential risk as well to financial enterprises. And just recently, the Fed and the OCC and the FDIC issued a guidance to their regulated entities telling them that they've got to start identifying and considering and addressing climate risks to those financial institutions that are regulated by those financial regulators. How do you do that if real economy enterprises are not disclosing the risks that they're facing, so that banks, insurance companies, investors, et cetera, have some insight into the risk they're then facing as they're lending to, insuring, or investing in real economy enterprises? So again, the critical importance of both bills is to provide disclosures that are necessary both to manage greenhouse gas emissions, but also manage financial risks to the financial system, to financial enterprises, and to real economy enterprises associated with climate change. So I'll stop there and turn the baton over to Dave.
Great, thank you so much. And I'll turn it, to Dave Owen. Thank you.
Okay, I've got a few slides, so bear with me just a second here. And okay, so I'm going to talk about water bills, and with apologies because I'm sort of a last minute fill in here, this is not going to be as comprehensive as you might like it to be. I'm not going to try to talk about, or maybe it is going to be as non-comprehensive as you would like it to be, but I'm not going to talk about everything that happened. Instead, I'm going to focus on two areas in which there was significant legislative activity. One is water rights legislation, the other is dealing with groundwater recharge. So here's a quick list of the bills that I'm going to talk about. I'll get into more detail on each of these. And just as background, you all know this, but we've been whipsawing between extreme drought conditions and massive floods over recent years. And at the same time that this has been happening, and we've been trying to think about how to adapt to this new, well, not new, but enhanced or exacerbated climate reality. There's also been a lot of controversy in recent years over California's water rights system, with concerns about how water rights are allocated, whether they are equitable, whether the system is effective. And so one of the more egregious examples in recent years was the illegal but unapologetic taking of water out of the Shasta River towards the tail end of the previous drought, which has become sort of, I think, a symbol of some of the larger problems in the water rights system. As background, to understand what's going on with these water rights bills, it's helpful to know just a little bit about California water law. And under California water law, we have multiple categories of surface water rights and riparian rights and pre-1914 appropriative rights. Those are the first two categories you see here, traditionally have not been regulated by the State Water Resources Control Board. Or if they have been regulated with a very, very, very light and limited touch. And that's because prior to 1914, you didn't need a permit to get a water right from the State Water Resources Control Board. And then there's evolved this long tradition of leaving those rights largely outside of the regulatory system. And that gets reinforced by some statutory provisions that grant somewhat unclear authority for the board to deal with those rights. So this led to, well, this and some other concerns led to a report by a group of academics pulled together by the Planning and Conservation League, which is an environmental advocacy organization that proposed a series of reforms to California water rights law. And directly out of that report grew three of the bills that I'm going to talk about in a moment. CLEE has also been involved in both of these spaces, actually, but on water rights, we put out a water rights report earlier this year that also points out real gaps in state enforcement authority and also in the information available to the State Water Resources Control Board. And so we can't claim credit for bills passing or not passing, but this was also very much a part of the conversation associated with these bills. So directly out of the PCL report and supported by our work, there were three major water rights bills that made their way through the legislature this year. One is SB 389, which is really an informational bill. It was designed to provide clearer authorization for the State Water Board to investigate water rights, including riparian and pre-1914 rights. Second, AB 1337, sponsored by Buffy Wicks. And this was providing curtailment authority for all water users, not just post-1914 water users. And so it was trying to give the State Water Board clearer authority over the pre-1914s. And then 460 is designed to create faster and more powerful enforcement mechanisms. So the ability to obtain interim relief relatively quickly, and also the ability to obtain larger penalties. And so these three bills all were making their way through. SB 389 passed and was signed into law by the governor. It had faced some amendments, but the core of the bill basically went through intact. And then AB 1137 and 460 both stalled in the Senate. And so neither of those bills has passed yet, and they will be put forward again next year. So they will become two-year bills with the possibility of passing during the next legislative session. Okay, the other big issue that the legislature took a look at this year is groundwater recharge. And the reason this was a particularly appealing issue this year is because we had so much flood flow. And we didn't have the surface water storage capacity to store all of those flood flows. And we can get into this later, but there are good reasons for that. Surface water storage has a lot of environmental impacts and loses water through evaporation. It's quite expensive. But the hope was that maybe we could capture some of that water and put it underground. And so that led to a couple of bills. One is there was a budget trailer bill with a lot of stuff in it, including other water things. But one of the more significant aspects of the budget trailer bill was to create expedited procedures for recharging flood flows. This basically meant exemptions from state fish and game code laws that require stream bed alteration permits, and also not even needing a water right to recharge water in circumstances where there were real downstream flood hazards. And so these procedures are designed to apply for limited periods of time during heavy floods, but to give people the ability to grab those floods and put some of that water underground. And then the other bill that went through is SB 359. And this bill requires the State Department of Water Resources to provide more extensive discussion of groundwater recharge in the California Water Plan. And it has a couple of specific items that it asks the Department of Water Resources to address in terms of recharge capacity and our ability to go forward with recharge projects. So again, that's a quick summary, and I'm happy to answer questions as they come up. Oh, and yes, I should say both of these bills were enacted. All right, so that is my summary. And now I'm happy to answer questions as they come up.
Great. Well, thank you all so much. And I would definitely encourage folks to put questions into the Q&A, and so we can go through those. Maybe we'll start with one question, and maybe start with you, Dave Jones, which is really to talk about implementation of the disclosure bills that you described, both on the financial risk side, but also on the greenhouse gas emission side. I think you mentioned that, there will be roles for the insurance commissioner and for CARB. What is the timeline for implementation and sort of the data that's going to be required, and how challenging do you think that's going to be?
So both bills place requirements on public and private corporations of a certain size and require them to do greenhouse gas emissions disclosure and climate-related financial risk disclosure, and make those disclosures publicly available. Both bills are narrowly crafted to limit CARB, which is the entity that's tasked with responsibilities under both bills, to a very limited set of roles. With regard to the greenhouse gas emissions reporting bill, CARB's role is to do a regulation by January 1st of 2025, which sets forth the parameters of the greenhouse gas emissions reporting protocol. But the bill itself directs that they utilize the greenhouse gas reporting protocol that's been in place for some time and utilized across the globe, was promulgated by the World Resources Institute and others. In addition, under the greenhouse gas emissions reporting bill, they've got a contract with a third-party nonprofit that will be a verifier of the reporting. Under the climate risk disclosure bill, that reporting doesn't begin until January 1st, 2026. CARB is directed to do a rulemaking around an administrative penalty, contract with an entity to set up a online portal to publish the reports, but its role is really limited. So as a former agency head who was tasked with implementing regulations that were enacted by the legislature, in reviewing both of these bills, I think that the lift here for CARB is not that great, and also that the timelines are accomplishable. Now, I will note in his signing statement, Governor Newsom indicated that he's concerned about the feasibility of the deadlines in the bills and has directed the authors to work with CARB on some cleanup legislation. I don't share that concern. CARB, under the greenhouse gas emissions bill, would be given a year in which to accomplish that regulation. They're not having to reinvent the wheel. They don't have to come up with a new greenhouse gas emissions reporting regime. They're directed in the law to use the existing greenhouse gas emissions protocol, which has been widely accepted and utilized internationally. So I do think that the timelines are feasible. The governor's signing statement also raised a concern about that protocol leading to variances in reporting across businesses. While it's true the protocol does leave a little bit of room for interpretation, typically businesses like that flexibility and don't like rigidity. And so I don't really understand the concern of the governor's office with regard to utilization of that protocol, because that is the commonly accepted, used international standard for greenhouse gas emissions reporting. One other thing too, I do want to note that the Climate Risk Initiative of CLEE first recommended back in 2021 in a report that we issued that California undertake climate risk financial disclosure. We actually drafted the first bill and provided technical assistance to the author and sponsors. So, we're very excited to see this enacted. It's been a long and winding road, and both bills were introduced in 2021, didn't make it through that session, were reintroduced this year, and over significant opposition from the Chamber of Commerce, they marshaled sufficient support to both pass and to get the governor's signature. They are big deals because they reach not just companies that are headquartered in California or incorporated in California, they reach any company that is doing business in California that meets the revenue standards. So essentially, California is setting, through these landmark bills, a national standard for both greenhouse gas emissions reporting as well as for reporting climate-related financial risks. Again, a national standard that's built on prior work. Both standards in both bills draw on existing standards that are being utilized across the globe. They don't reinvent the wheel, and it should be relatively easy for companies to comply with them.
Great, thank you. A question for you, Dave Owen, in the Q&A was just whether was there any legislative action around water efficiency or water recycling that you were aware of this session or recently?
So this is where the this is not comprehensive disclaimer comes in. There was some action around water pricing, which relates closely to water efficiency, because prices and efficiency, prices are an incentive for efficiency. And as well as an extension of, under the trailer bill, of some other programs that could be used as grant money for water use efficiency. My knowledge of that is really skim, so I can't really go into much more depth than that.
Great, thanks. Ethan, a question for you from the Q&A was, you alluded to some of the discussion around hydrogen and with some of the transportation bills. And I think also with the announcement, obviously, of the Hydrogen Hub Award in California, a lot of activity and discussion of hydrogen right now. So I wonder if you could just give an overview of some of the issues that, you know, have been coming up in the legislative discussions around hydrogen.
Yeah, so I mean, the issue with that specific bill was that there were some legislators that wanted a specific funding carve out for hydrogen fueling stations. And that's somewhat controversial because, you know, I think first of all, some people have objections to hydrogen, which I can talk about, but also just the idea of a carve out for that technology when we're seeing so much success with battery electrics. Now, in terms of the sort of overarching hydrogen debate, I shouldn't say overarching, that's sort of an inadvertent pun, because the state hydrogen application is under the ARCHES. That's the acronym for the hydrogen proposal. We just got $1.2 billion from the federal government to create a hydrogen hub through ARCHES here in California. Controversy around hydrogen is basically that there's no cheap way right now to produce it from zero emission sources. Right now, the hydrogen that you're using to fuel your Toyota Mirai, if you're one of the less than 1,000 people in California that has a hydrogen fuel cell vehicle, that's converted from natural gas. So hydrogen is basically a fossil fuel right now, and a very inefficient one because there's so many energy losses to first make the hydrogen and then have it convert to electricity in a fuel cell vehicle. However, there's a lot of hope that hydrogen could fill in those gaps where cheaper battery electrics and renewable energy, electricity basically can't decarbonize. So that would be industrial sources, potentially aviation. And I'm co-chairing the aviation working group of the ARCHES proposal that now funded, as I mentioned, by the federal government. So, I think there's a lot of interest in exploring hydrogen for those sort of hard to decarbonize sectors where electricity is not going to necessarily fill the gap. But there are still some folks who believe hydrogen has a role for light duty vehicles. I'm not one of those people. I think batteries have proven that they're cheap, very reliable, and clean. We know they can be powered by clean electricity. So that was basically the controversy for the specific bill, and then that's some of the challenges around hydrogen. Other people think, look, we need light duty hydrogen to help kind of scale up hydrogen in general. Then we can apply it to these other harder to decarbonize sectors like industrial uses and aviation and so forth. So, and also I should mention, there's a lot of environmental justice activists and advocates who are concerned about hydrogen because of its method of production, because it may provide a lifeline for some fossil fuel interests to keep burning fossil fuel and some natural gas power plants, et cetera. So there's a lot to those issues. We don't have time to go into all of them today, but that's a little preview of some of the controversy around hydrogen.
Great, thanks. Dave Jones, can you speak to how many companies will fall under the two SB 253 or 261 that will also be operating in the European Union, so also subject to their latest ESG requirements, which actually from this question indicate they go beyond ours. So I don't know if you could speak to sort of California's framework as it pertains to the EU and sort of how many companies will fall under both.
So I'm not aware of any analysis of that intersection, so to speak. I mean, on its own, the greenhouse gas reporting bill, SB 253, will land on some 5,300 companies. The financial risk reporting bill, SB 261, will land on about 10,000 companies. The difference between the EU standard and these two California laws is that the EU standard, while very much aligned with the California laws, also incorporates a provision of double materiality. So companies having to report under the EU directive will have to report both risks to their operation that are financially material, as well as risks they pose of impacting on the categories of concern in the EU directive, which go beyond climate, by the way, but include other environmental and social and governance considerations. But the notion is that a company needs to look at the material risk to itself, as well as its material risks externally. that's a different standard than what California is enacting, or what the SEC is proposing, or what the federal government is proposing in its federal procurement rule, which would also adopt the TCFD framework for federal government contractors of a certain size. So the EU rule is broader, but it also relies on the same sorts of underlying standards, whether it's the greenhouse gas protocol or the TCFD reporting framework. So there's a lot of alignment between the two. And, a read of the climate risk financial disclosure bill says explicitly that if someone prepares a report that is consistent with the requirements of the California law, but is being done subject to another governmental entity, in this case, the EU or a national government, the EU, they wouldn't have to duplicate reports. One report could satisfy both.
Great, thank you. Ethan, I'm going to direct this one to you, which is whether there were any bills introduced this year around around carbon capture and sequestration. I am not aware of any, but I don't know if you are.
Yeah, none that made any headlines. There may be some bills that sort of did some detailed type work, or maybe some of these existing energy bills that I mentioned might benefit carbon capture as well. To the extent it's going to connect to the electricity grid, there would be some benefits from the electricity grid streamlining bills that I mentioned. But yeah, nothing else that jumps to mind.
Great. Dave Owen, you mentioned that 2 of the 3 water bills, specifically AB 1137 and 460, are now 2-year bills. Do you have a sense of what the next steps on those bills will be, or sort of what the issues are that need to be worked through to keep them moving?
Yeah, so the basic issue is that all 3 of these bills had pretty widespread opposition from water users and their political representatives. And on SB 389, excuse me, they came out with a very united front and very uniform opposition, and that bill very nearly didn't get out of committee. It got out of the Senate Natural Resources Committee just by the skin of its teeth, and then actually had an easier path from that point onward. But that bill seemed to have less opposition from the water community. There were sort of behind the scenes signals like, we don't love this, but we're kind of neutral on it, or we actually think it's kind of a good bill, we can live with it. And so it went forward. And the other bills got through the assembly, which is actually the easier place for a water bill to get through right now, or at least a regulatory water bill. But then they both stalled again in the Senate Natural Resources Committee. And the basic issue there is that you have, like most committees or all committees, it's heavily stacked with Democrats, but you have a lot of Democrats who are from the Central Valley or from agricultural areas, and for whom, what the local water district says matters a great deal for their ability to get reelected. And so that it's a really difficult, all of these bills put those representatives and senators in difficult spots. And that particular view is particularly well represented this past year on Senate Natural Resources, and it will be again next year. So what will make them go forward? It may be concessions, it may be some sort of compromise, it may be a stronger narrative surrounding the bills, and it may be that they won't pass. But that's the challenge ahead for the coming year, is really that Senate Natural Resources Committee.
Great, thank you. I guess we already talked about those 2 bills that are 2-year bills. Dave, Jones, or Ethan, are there any other bills that were introduced and discussed that could be important that didn't make it through this year?
Well, I could start. So I mentioned at the beginning that I wasn't going to talk about housing, at least as an opening salvo here of bills, but housing is obviously central to our climate goals. I mean, the more that we are building auto-oriented, subdivisions out over open space, agricultural land, the more we're straying away from our vehicle miles traveled reduction goals, the more we're losing opportunities for carbon sequestration, the more we're building homes in climate risky areas, the more we're building homes that need more energy to heat and cool, to bring water in for outdoor irrigation if they're single unit dwellings. And of course, VMT has its own impacts, even as we move towards zero emission vehicles. Certainly means a lot of time wasted and money wasted for people who are living in far-flung areas where that's, where they often can best afford a new home. And even if we have a lot of electric vehicles, that has a huge land use footprint if we have to build more solar and wind farms to power the electric vehicles. So housing is really central to everything that we do. And there was a bill, AB 68, that did not make it this session. It's a 2-year bill, but it would really start to move for the first time, move the state towards a statewide zoning code in some ways. I mean, I'm sort of overstating it, but basically it was a state telling locals, if you have transit, if you have a lot of jobs and housing, a lot of transit, and we need more jobs and housing in those transit-oriented areas, there would be some upzoning and streamlining of permitting to encourage more apartment buildings in those transit-friendly areas. And if you're out in climate-risky areas, subject to wildfires, flooding, et cetera, sea level rise, that the zoning code essentially be frozen. Local governments couldn't upzone and increase density in these areas, putting people in harm's way and also undermining our sustainability goals at the same time. So AB 68 is a 2-year bill. I believe it's coming back next year, but that's the kind of approach we need in California. We need to be kind of undoing that seesaw where it's hard to build in the cities and easy to build 100 miles from jobs. And we need to undo that and make it much easier to build apartment buildings near transit, near jobs, where people don't have to drive. And it should be much more difficult to build these kinds of homes that are putting people in harm's way and that are undermining our climate goals at the same time. So AB 68 is the bill I would mention there.
I'm not aware of any other bills that were introduced that didn't move on the topic of carbon pollution or financially related climate risk disclosure in this session. Although I will say, I'm sure that every member who had a bill that touched in any way on climate felt it was an important bill and it should have gotten out. But I'm not aware of any others specific to the climate risk disclosure realm.
Great. And there's a question in the Q&A, and I'm not sure if anyone will has been following this, which is legislation, whether there's any legislation related to the U.S.-Mexico border region, particularly as it relates to water or air quality.
I was just starting to type an answer. Okay. I'm not aware of any. That doesn't mean it doesn't exist. That just means I don't know about any.
Yeah, I'm not aware. I think the questioner, Aaron, is familiar with the Lithium Valley proposals and Salton Sea, and I don't know of any particular legislation that was passed there. Although, again, the electricity grid bills that I talked about, to the extent we need to get more geothermal from the Salton Sea online, these we've got procurement powers with Department of Water Resources now, and we have an expedited process for grid energization. Could presumably help some of the clean energy resources in the Salton Sea area on the border there, or near the border.
Louise, I want to amend my prior answer.
Okay.
And in part, I guess I just have a PTSD about this, but there was a bill that never actually saw the light of day, but which a number of interest groups were proposing at the end of session that would have made some significant changes to the way in which California regulates insurance rates. And why this relates to climate change is that climate change is causing more severe and frequent weather-related events, which are killing people and injuring people and destroying communities and destroying property, and also causing larger and larger insurance payouts. And we're starting to see more insurers decline to renew insurance for particular homes that they view are too risky. And in some cases, some insurers have said they're not going to write new insurance or they're going to cap their insurance. And so there was a bill proposal that never was introduced that would have made changes to and provided more opportunity for insurers to get more rate in exchange for, and this is in rough measure, they're agreeing to write more insurance in the areas at greater risk. That bill ultimately did not get introduced, but the insurance commissioner, based on his regulatory authority, took some portions of those ideas and announced that he's going to try to undertake a rulemaking to adopt some of that in a new rule. So more to be reported on that. It's going to take about a year. The devil's going to be in the details. We haven't seen anything in writing yet. But to your question about something that some people thought was really important that didn't happen, it was this insurance bill that ended up not actually being introduced.
Great, thank you. And I know someone put in the, excuse me, in the Q&A, another 2-year bill, Senate Bill 233, sponsored by Nancy Skinner, which would require all electric vehicles to have bidirectionality. So allowing the vehicle to grid, enabling vehicle to grid. So that's a bill to watch. I will try to, there's a nice link. Let's see if I can figure out how to, I'll put it in the chat for everybody. So that is another one. Thank you.
And I'll just kind of jump in on that one, Louise,
yeah,
real quick.
please.
That is a really potentially important bill. One of the knocks you hear about electric vehicles is, oh, the power's going out. We can't have reliable electricity. How we expect all our cars to run on electricity? But what people don't realize is electric vehicles are a grid asset. I mean, they can actually help keep the lights on. And if you have that bidirectional charging that people can plug in, especially they can get paid to plug in during times of grid shortages like we had last September when there was that, almost unprecedented heat wave across the Western United States. Imagine if, between 6 and 9 p.m. when solar is decreasing, we don't have enough natural gas plants, and hopefully we'll be phasing those out anyways. Imagine if people were paid to plug in their electric vehicles and actually provide power to their communities. Right now, homeowners with batteries can do that. They can sign up for a plan to discharge their batteries, but electric vehicle owners could do that as well. They could also keep on the lights to their own house. I actually did this with my Chevy Bolt a number of years ago when there was a power outage. I ran my house off of my Chevy Bolt. Please don't tell Chevy, because I believe I violated the warranty, but it was a lease vehicle and I returned it, so I'm okay now. But I had to kind of jerry rig something, but that's out there for people. I mean, imagine if your vehicle becomes your home battery backup at the same time. So that's something that people miss with electric vehicles, and Nancy Skinner's bill could make a big difference there. And it's the way the whole world is going with this, and the industry. I mean, Ford F-150 Lightning comes with that possibility built in, but a lot of automakers don't allow that. This would really help encourage the industry, require the industry to come on board with that.
Great. Maybe I'll ask you, Ethan, if you have a 30-second answer to one last question that just came in. Do you have insights into why the governor vetoed SB 420 by Senator Becker that reduces permitting requirements for electrical transmission facilities? Is that one you followed?
I only know the sort of scuttlebutt. I'm not an insider, but I think this was reported that the PUC got to the governor's office and basically asked him to veto it. And there are a lot of people upset about it. Not something I was following that carefully. And, I could be wrong. That's just what I believe was reported on. And I've heard from a few insiders, but I'm not an insider myself. So take that for what it's worth.
Great. Well, thank you. I want to give everyone a minute to just sort of wrap up and share a few final thoughts from each of our experts, which is just if you all could share, what do you see as major priorities for the coming year, either within the legislature or just from a policy standpoint, based on what we talked about today? Maybe I'll start with you, Dave Owen.
Okay, so I'm focused on water, and I think we have a long way to go, even to catch up to some of our other Western state neighbors in tracking our water rights, understanding the scope of those rights, understanding who uses what, and then enforcing those rights and making sure people don't go beyond. A quick example of this, I was at the Yosemite conference a couple of days ago, and there was a presentation from one major water rights holder alleging that another water rights holder was taking hundreds of thousands of acre feet of water illegally every year, and nobody could verify because it was a pre-1914 right. So I think that's an example of just how much work we still have to do on water rights administration and enforcement.
Dave Jones?
So first and foremost, it's implementation of SB 261 and SB 253. And, that would include the governor putting some money in the budget in January to assist CARB in implementation of those two. Although, again, I don't think either are a heavy lift. It's a little concerning that the governor's signing letter raised some concerns in this regard, but hopefully on the merits, it will be concluded that it's not necessary to make significant delays in the implementation of both these bills. I think at the federal level, the SEC finalizing its rule for stock companies with regard to financial risks associated with climate change is critically important. Gary Gensler, the SEC chairman, commented the other week favorably upon California's enactment of its financially related climate risk disclosure bill, saying it's going to help the SEC, probably in no small part by the fact that they have to do a cost-benefit analysis. If California is already applying it to some 5,000 companies or 10,000 companies, actually, some of which are stock companies, that means the financial impact of the SEC doing it is less. And then getting U.S. federal financial regulators and state regulators, including state insurance commissioners, to take up climate risk stress testing, which is a tool that European regulators and Asian regulators are using to actually test the balance sheets of banks and insurance companies against various climate risk scenarios. We're behind in that considerably, and we need to catch up.
Great.
And I'll just add, in terms of future trends, I mean, I think it's going to be more about implementation, like what we've seen with this past session, dealing with these sort of governance processes that get in the way of clean technology deployment. I think on the housing side, you're going to see this continued push to try to streamline housing approvals for transit-oriented areas, but there's a big battle there, particularly with the construction trades, because they're insisting on a prevailing wage, which adds a lot of costs, which means only high-end projects get built, if any. So we're not going to meet our housing goals with that. Otherwise, I mean, what I'd like to see some legislated goals around building decarbonization, moving to all-electric buildings. I'd like to see something on fossil fuel production in the state, setting a date certain for when we're going to be phasing out fossil fuel production. But who knows? These are politically controversial decisions, and we've got a governor who's kind of playing to a national audience more than a state audience, if I may opine on that. So we're not going to see a lot of risky stuff happening, which is a little bit too bad, because some of the stuff is urgent. It's obviously all urgent, and some of the stuff is controversial, and so we really need leadership to get this done.
Great. Well, thank you all so much. Thank you to everyone who joined us today. Thank you, Dave, and Ethan, for sharing all of your expertise and insights on this year's legislative session. And thank you again to our partners, Wilson Sonsini, Oric, and Hanson Bridget, for supporting our Lunch and Learn series. And thank you to everyone who joined us today.
Thank you for moderating, Louise. Appreciate it.
All right.